my suggestion. I'd be happy to, respond to the general counsel of either organization to say, yes, please.
That's what we're looking for then. They will not, you just said, Mr. Ashton just said that the council will send it to them. That's the whole point, Your Honor. They don't send it to us. They send it to them, not to us.
I don't know that. You haven't even made a request.
But he just indicated that to you, Your Honor.
Well, that's good. Make a request of them, Mr. Ashton. If you do get anything from them, immediately notify the court and a copy over to defense counsel. Absolutely. I'm not going to deny the motion. The motion's moved as of this point. We've dealt with it once before, though, back in December.
Yeah, I was not here, Your Honor, and these were not, and I don't know whether it was, I saw the moving papers, but these were very specific requests, as I know that things have been granted previously. Your Honor, with the issue that you have no jurisdiction, even though there was a press release indicating that the third parties would be saying that over third parties there was no jurisdiction when the state is using them as their experts to get documents from them?
You want to respond? Yes, that's correct. These organizations exist outside of the state of Florida. So far as I'm aware, unless counsel can educate me with some Florida law of which I'm unaware, this court's subpoena power ends at the border. They're involved, but they haven't submitted themselves to the jurisdiction of the court yet, as far as I'm concerned. The state may have listed some of these folks as witnesses. They're not here. And I would like to short-circuit some of this as much as you would, but I can't order Mr. Ashton to get the discovery for you.
What I'm trying to ask, Your Honor, is that if indeed listed as witnesses, does that put them within the jurisdiction of the court, so we don't have these arguments further on?
I don't know that it does, if you're listing them as witnesses.
What would Your Honor suggest? There's no law on this. I checked Florida case law because I don't think anyone's ever fought for bench notes before, Your Honor, but normally they're given. So there is no case law that we can find.
Based on my conversations, that counsel is going to get the bench notes she wants by simply making 2 phone calls. So perhaps we could, but I just want to assure the court that there are many things requested here that go way beyond bench notes. Some of those things I would expect them to object to for proprietary and other reasons. But once an objection is made by them, if they do make an objection, I have a feeling they'll hire counsel that will come in and argue this. So you need to come and make the request, and we need to distill this down to who it is that's going to be arguing over what. As this stands, they haven't even been noticed, and you're simply asking the state to give this to you, and the state doesn't give it. So for now, I'm going to ask you to go ahead and get in touch with the Oak Ridge Lab in Tennessee and see what it is they will give you. If there's anything missing after that, it's probably going to have to be brought in before me. If the state doesn't have it, won't give it to you then. I assume they'll hire lawyers.
Well, can I ask whether the state is opposing objections to any of the specific things? Because one thing they're going to want to know is if there's any objection from the prosecutor. That's going to be, if the state objects to specific things, I think we're entitled to know.
Then they can call me and I'll tell them what I don't object to. But there are 2 matters within this lengthy motion that aren't subject to that objection. If I could just briefly talk about those real quickly. Paragraph 23, there is a request for a copy of a DNA parentage report as set forth in discovery, page 3240. Counsel has that. It is on a disc which is titled Melich Case Report. It is contained within that, I believe it's a CD or DVD that was provided previously. So that they have, and it is in that form, and that's what it refers to. The only other thing is there are requests that have to do with Dr. Garavaglia, who obviously is within the court's jurisdiction, and I believe the county attorney is here to address those requests. So my statements don't apply, obviously, to Dr. Garavaglia because she's
that's number 19, and there is the county attorney.
I believe so.
Would somebody like to speak to the request?
Your Honor, just go back to that. Mr. Ashton said if the call, we won't find what they don't object to. There was a discussion, I understand, with Mr. Baez and one of the prosecutors that some things would not be objected to, and we're not entitled to know what that is at this point so that we don't have to worry about that when we go to the FBI?
At this point, Judge, it really is more up to the institutions involved to object or not. And I think at this point, for some reason, we don't seem to be able to just take what's being given. I'd like us to see what can be done without litigation first, and then determine what we have to litigate. And I basically...
I'm done speaking to that. The bottom line is a request needs to be made of those agencies, and then if a legal dispute develops off camera. Having said that, let's go to item number 19, which is has to do with items at the Orange County office basically all contract records, payments, documents, memos, or any written items, including but not limited to drafts, proposals, or otherwise involving media specified. So, do you have a copy of this report?
I do, yes.
All right.
Your Honor, Mr. Biles will handle that, but Your Honor is not denying this motion. That's my understanding?
Your amended motion?
Right, it's not being denied.
No, I'm not denying.
And the prosecutor doesn't have to indicate what they're agreeing to or not agreeing to. We'll wait and see what the objections are for the third parties, and then, is Your Honor then saying, or they're saying that they can impose additional objections even if third parties agree to give it to us or not? I'm not quite sure.
We don't do anything once we find out where the FBI stands and what the evidence lab and the FBI, they may send you all of this, and if that's the case, we're not going to have an issue.
Well, if the FBI indicates that we need the consent of the prosecutors, can we do that without coming back to court?
Say that again?
If the FBI indicates that the prosecutors have to request it, that we're not going to send it to you, can we do that without coming back to court, Your Honor, and getting an order?
I'm not sure I'm following you.
Right. If the FBI says, we object to this, however, you can have the prosecutors ask. I don't want to come back on a motion and to force the prosecutors to ask. What I'm trying to see is if there's a shortchange here, that's what we're trying to get to, is ultimately it's going to be the prosecutor's objection. If they're consenting to this...
We can meet again and discuss that then if the state has, if we reach that point and if the state has a specific comment or objection.
Okay. Thank you, Your Honor.